It's a great pleasure and honor to open this panel. So first of all, let me thank the hosts, Dinta Barash and Professor Kiwaru for inviting us and organizing this wonderful event. And we have a panel that should be very interesting with first-rate speakers. Let me introduce them one by one. Professor Armin von Bogdandi, who's the director of the world-renowned Max Planck Institute for Comparative and International Law. Professor von Bogdandi will speak about a topic that is dear to him, about which he published recently a book, namely the attempt to reinvent the configuration, the current configuration of Europe around the concept of society. Now, which of course is the link in Article 2 between values and principles. The second speaker is Dr. Mendelsky, who's a political scientist with whom I have personally worked before. It's a pleasure to see you again, Martin.
Meanwhile, a social scientist.
A social scientist.
Social engineer.
A social scientist. He wrote provocatively and interesting, I mean that as the highest compliment, about the evolution of conditionalities in Romania, anti-corruption conditionalities, also in the Western Balkans, in the current candidate countries. And last, certainly not least, it's an honor and a pleasure to introduce our ombudsman, Mrs. Renate Weber, who I dare say is the ombudsman who did what the only ombudsman in my experience who did what the Constitution says the ombudsman should do, namely defend the rights and the liberties of physical persons. And it's a great pleasure to introduce all three speakers. Now, Professor von Bogdandi is identified as a keynote lecturer, but I suggest we should take all the presentations and have the discussion at the end for all three of them. So you should have about 20-25 minutes per lecture. Professor von Bogdandi, you have the floor.
And I'm very pleased to have the floor. So good morning, everybody. It's a true pleasure to be here. And I'm very grateful to Professor Giumario, who is just leaving the room, but it's not for me, right? It's a great pleasure to be here and to have the opportunity to share some thoughts on the question of the rule of law. And the title of our conference is The Rule of Law After the Pandemic in Times of War and Economic Crisis. So the core message that I have for you is a rather trivial one. The message is that the rule of law in these times is more important than ever before. And I think that's not a great surprise, but I will try to elaborate on it, and I will try to elaborate on it in a new perspective so that the talk becomes more interesting to you. And that brings me to the title of my talk, and that is that the emerging European society could be used and should be used as a focus to study the challenges to the European rule of law. So we take the concept of a European society, which is dear to me, and let's see what we can learn about it on a topic that we all know very well. So trying to give it a new twist, and that twist helps us to see it a little better. So I will do it in 5 steps, which go around 5 questions. So step number 1, question number 1 is, what is European society? Then, and I will tell you, it's not a fantasy of an academic, it's a legal concept that we have to work with. It's a legal concept, a core legal concept. Then the second step is, why is the rule so important for the European society? That is then the second question. And I will tell you, it's very, very, very important. Then I will go to the question, why is the rule important now after the pandemic? I'm not so sure if we are truly after the pandemic, because at least in Germany, the hospitalizations go up and up. But anyway, why is the rule of law after the pandemic now more important than ever before? And Also, there's an easy answer. That is because we are sharing so much money. It's also, and then can there be improvements of the rule of law? And there I'm having an argument with two gentlemen to my side, so it might also be interesting. And then the last question is, why is European society so important when we are discussing on how to improve rule of law? So that are the 5 questions that I will develop over the next 20 minutes. So the first question then is, what is European society? And that brings us to the one formulation about European integration that we all know, but we don't know really so much what it means, and that is the ever closer union. And you know that has been the motto of European integration now for 70 years, so the ever closer union. So what is the ever closer union about? And in the process of integration, there have been various proposals that were a no-go, not least because of the constitutional court of my country. So a European federal state, that is off limits. A European nation, that is off limits. A European people, that is off limits. But nevertheless, we need a concept that gives us an idea who we are. Now, the European treaty maker found an answer to that. And I want to recall to you the European treaty maker that are the political systems of the 27 member states combined. So it's not some bureaucrat in Brussels or some academic in his ivory tower, but the 25 national systems gave an answer to that in the Lisbon Treaty, and not anywhere in the Lisbon Treaty in Article 347, second paragraph, fourth subparagraph, so somewhere buried down there, but in Article 2. So. And that is that 70 years of European integration have achieved European society, one society. So the political systems tell us that all of us here, that we form one society. So the idea is, and the impression is by the treaty maker, so by the political systems, that the quantity and the quality of relationships that exist nowadays between our national societies have created something new, and that is European society. In that respect, this event today is an event of European society, and I think it's not so difficult to grasp that. Now, think back 20 years. And think back 20 years how such an event would have been. It would have been a very, very different thing. It would have been a largely diplomatic event. It would have been very difficult to find a true common topic, and it would have been even more difficult to find a common language and to truly engage. And I think, as we did yesterday at Bogdan's conference, today we can truly engage over common topics. And I think that is one proof that what the treaty maker wrote in the treaty in Article 2, that we are one society, that there is also sociological substance to that. Of course, that does not mean that there is harmony. Indeed, society thrives by conflicts, and probably also today we will have conflicts over the very contentious issue on the rule of law and what to do about the rule of law. But the very point that we can discuss controversial issues, that is one of the core elements that we do have a society. So that is the first point. What is European society? It's a concept in Article 2 by which the treaty maker gives an answer to what has been achieved by the ever closer union. That is to say that today we form one European society. First point. Second point. Why is the rule of law so important to European society? That is, and that again is, if you look into Article 2, we see that the rule of law is one of the, so Article 2, it has 12 principles, like the European flag. And you know, 12, it's the perfect number. you have all wonderful symbols with 12. So there are 12 principles in Article 2, and the rule of law is one principle. But if you read the jurisprudence of the European Court of Justice, and also if you read the most important legal document that has been created over the last years, and that is the conditionality regulation, and the most contentious one, you see that now in our understanding, those 12 principles are related. So to have the rule of law, you need human rights, you need democracy, you need a parliamentary process, you need a pluralistic society. So the rule of law and the other principles, they feed into each other. There is no rule of law without democracy. And to tell Prime Minister Orban, there is no rule of law and there is no democracy without pluralism. So these, for the European treaty maker, in the European society, these 12 concepts go together. So if we defend one, we have to defend all of them. And they also have to be developed and interpreted, one in light of the other. So there cannot be an antagonism between the rule of law and democracy. We have to find a way that these two principles are developed together into sound institutions. That is the second step. Now we are coming to the third step. And the third step is, why is the rule of law more important now after the pandemic? And that is because European society has made an incredible step. An incredible step that until 2020 was unconceivable. So many people say, and they don't say that as a compliment, that I'm someone with a lot of fantasy. To some, that is not meant as a compliment. But even if I have a lot of fantasy, to me in 2019 it was unimaginable that the European Union would ever do a step with Next Generation EU as it has done. It was a red line for so many member states that you cannot imagine, or that the European Union is allowed to take up debt in order to feed the needs of European society. It was something which was considered totally off limits. But nevertheless, the step has been done, and it has been done with astonishing little controversy. With astonishing little controversy, that we do one thing which is so essential for a working society, and that is solidarity. So a well-working society, there is a strong element of solidarity. Also, capitalist societies can be solidaric. Indeed, I would say that capitalist societies can be more solidaric than socialist societies because there is more wealth to distribute. So European society has made an enormous step with this Next Generation EU to take up a lot of debt to support the people and the countries and the institutions who need that. And many of you know, many people have said that that has been the Hamiltonian moment for the European Union. That is to say, the one step when in the US the federation took over the debt of the states. Many say that that was the crucial moment for the United States to become one country, Hamiltonian moment. But also, as you all know, so far, this instrument is conceived as being temporary. It is thought to be phased out. But at the same time, we see new challenges with the energy crisis, with the Ukraine, with all the new crises that there are. They are all very costly. And the question is whether European society can take another step in order to pay for Ukraine, to pay for the energy crisis, which at the moment is so much at the heart, and how do we finance it? It's a question of money at the very moment. So how to finance that? So a core question is whether that instrument can become a permanent one. It's crucial for our future. But of course, that needs trust. If many citizens in the European Union don't have the trust that that money is spent well, but that it goes to other directions, then that is not sustainable. So there's one example which so I'm a pro-European person, but for example, one thing which to me is very, very hard to imagine how to defend it is in Italy, the 110 rule. You know, you invest 100,000 in your house and you get back from European money 100,000 you invest and you get back 110. So it needs no imagination that that is a recipe for corruption and bribery. It's evident, no, that is very hard that money is spent well. So it's a huge challenge, and it needs very strong mechanisms to convince all Europeans that these 110,000 is money spent well, because otherwise, you know, we all pay for that. Our children have to pay for that. We might get very angry if we find out that just two people, they come together and they say, well, you write me a bill that I have renovated your house for 110, and then we share 55-55, and perhaps you do something with my plumbing. Yeah? And that is a true debate now in Italy. How can you check so many problems? So it's a very, very important thing that after the pandemic, even more than before, that money is spent well, and that we can continue with these programs, that there is trust. Now, the rule of law is a foundational element that you have to have trust. Now, can improvements of the rule of law be achieved? Now, yesterday we had a conference on that topic. Bogdan Janko organized it in the New Europe Center, and it was a very rich conference. And there was much skepticism, if that is possible, to improve the rule of law. And one of the main things was that the rule of law instruments, the instruments that there are, like anti-corruption institutions, anti-corruption legislation, that those instruments can be perverted. That those instruments, although they are signed and declared as being rule of law instruments, that they are used for other means, and particularly for a partisan political combat. That is something that has been discussed yesterday at length, and I think that Martin Mendelski will perhaps develop on these issues.
Not today.
Not today. Okay. So of course that is a true problem. That is a true problem, and I think that is something that needs to be discussed. And I will come back at the end. But and me, I'm not a specialist on those instruments, so I can only observe. But the one thing that I can tell you is that it is essential for European society not to give up, not to take the position that there cannot be any improvements with the rule of law, but to try to continue trying. And it is essential for at least three reasons. The first reason it is that it is for its good functioning. So we all know that Europe is built on law. Law is a mechanism to support a specific form of normative expectations. And if the law does not work as a true mechanism that supports normative expectations, then the whole thing crumbles. And that is even more the case in European society than it is in national societies, because in national societies you have many more mechanisms to support the functioning of society. People know each other, they know what to be expected, there are more social norms around, so there is more normative stability in a nation, in a people that has grown over centuries than there is in European society, where we don't have so much informal normative expectation. For that reason, law is more important to European society than it is within national societies. Although I dare to say that even a modern, differentiated society cannot work well without a working legal system. So the first reason is that we need it for the good functioning. The second reason is that we need it for our self-understanding. So the treaty makers, so our parliaments, they have told us that we are living in a European society which is characterized, not just committed to, but characterized by the rule of law. So, to be characterized, that means it's much more than just to be committed. So you can say, I'm committed to something. I'm committed to eating less chocolate, but you know how things are. It's a good thing, and I fail. Now, if I'm characterized, so I can say I'm committed to eat less chocolate, but I cannot say I'm characterized by eating no chocolate, because that's not the case. And the same thing is with European society. It's not just committed, oriented towards the rule of law. It is, the treaty maker says, it's characterized by the rule of law. So if there are severe problems of the rule of law, it goes to the heart of European society. It goes to the identity of European society. And the identity concept has come up now in the landmark judges, probably the landmark judges of the Court of Justice of this decade, which is the one of Poland and Hungary versus Council and Commission. That's to say, the case on the conditionality regulation. You know, as the court presented it, that has been at least the most important of the year and probably the most important of the decade. And to show how important it is, the court makes a very important step, conceptual step, in that decision, because for the first time it speaks about European identity. And what is at the heart of European identity? It's the rule of law, which is defended by the rule of law, the conditionality regulation. So it is core to our understanding, and we might even go a step further, and we might say that it goes to its very existence. Because I think it is not certain, but it is likely that if we start to fight about these instruments, like the conditionality regulation, there might be very destructive processes in European society. And it's not far-fetched to say that there might be controversies that put the whole thing at risk, which is something, as we know, that some other countries are just looking for. So if there is any fault line in European society, we know that there are very able foreign agents who will feed and feed and feed into those fault lines in order to make the whole thing explode. Now that brings me to the last point. Why is the lens of European society, in my understanding, so important in that respect? The usual way how these issues are discussed is to pit one country against the others. It's the northern countries against the southern countries, it's the western countries against the eastern countries, it's the rich countries against the richer countries against the poorer countries. That's one way, and the way how it is mostly framed, that type of debate. Now, the concept of European society helps us to overcome that cleavage, which is a very bad, nocive, and destructive cleavage, to pit one country against the other. So what the concept of European society tells us is that that cleavages, how to implement the rule of law regulation, what is a rule of law problem, what should be done in with a certain institution. It is not a Danish or a Bulgarian question. It's not a cleavage between a rich country and a poor country, or a Western country against an Eastern country. But it's a cleavage within European society. So for any position of any of these issues, you have German and Bulgarian and Romanian and Estonian and Italian people speaking in favor of one solution, and you have Swedish and Hungarian and Spanish and French people speaking for the other solution. So the cleavages that we see, in my understanding, are not cleavages between countries, or we should not frame them as cleavages between countries, but we should frame them as cleavages within European society. And I think that gives it a more productive reading, because it takes out the very dangerous, toxic bilateral relationship between countries, between the ideas, between center and periphery, with all the national stereotypes that go with it, which are very toxic and very nocive. I think the concept of European society helps us to overcome that. And I think, and with that I can then conclude in 25 minutes perfect. I think in that respect, if we take it that way, I think we can say that European society is far advanced over US society. And why is that? Because we have that cleavages, but we continue speaking, and we continue looking for compromise. And in European society, compromise is not betrayal. Compromise is not treason, as it is now in the US between the Democrats and the Republicans. Any compromise is treason, is betrayal of the just cause. In Europe, we are on a different page. We see that compromise is at the heart of democracy. For that reason, I think in very important respect, European society is more advanced than US society. Of course, to conclude, also compromises can compromise democracy. It's a play of words, but I think it is not every compromise is valuable. There can be bad compromises that are toxic to the 12 principles. There can be, and I think one of the core roles that we have as academics is to find those out and to make it public so that European society can act on it and mend them. So that is my input to this conference. Thank you very much for your attention.
Okay, so thank you very much for invitation. And I'm from University of Mainz, originally from Poland, living in Germany, in Trier. I obtained my PhD from Luxembourg University, and I'm married to a Romanian. So this is my connection to Romania. I studied also in Romania, in Iași, for one semester at the European Studies. And now I'm asking myself, what are rule of law conflicts? This is the question, basically, the research question. And some of you would say, rule of law conflicts are legal conflicts. Legal conflicts about legality, about supremacy of law, about constitution and the interpretation of law. Others would say that rule of law conflicts are constitutional conflicts between guardians of the constitution. Maybe another group would say these are political conflicts over sovereignty. Then again, others would say maybe these are broader conflicts about epistemic issues, about knowledge, about beliefs, about reality, about threats and risks. How do we perceive risks and threats? And how do we perceive real risks and hypothetical risks? And maybe, again, a more narrow group would say these are factional conflicts between two groups or between two coalitions, between two groups of judges, could be also rule of law conflicts. And I'm arguing actually that the rule of law conflict combines all these conflicts together, and I call this overlapping polyconflict. And this is basically the main message, the main argument, which I want to present here. So the research question, what are rule of law conflicts and why do they persist in the European Union? The answer is the hypothesis, rule of law conflicts endure because they have turned into overlapping polyconflicts. They are entangled and various conflicts overlap, and it is difficult to disentangle them. Of conflicts occurs in distinct spheres, the legal, constitutional, political, epistemic, and factional sphere, or group sphere, about contested concepts. The concepts are legality, constitutional identity, sovereignty, knowledge, and legitimacy. So the conflicts are about these concepts, these contested concepts, and overall they get an entangled, overlapping cleavage over the rule of law. Graphically, you can present it like this, with overlapping conflicts. And if you consult the literature on legal conflicts, on legal disputes, on constitutional disputes, political disputes about sovereignty, you end up with this table. I hope it can be read, yes, a bit small. But let me start with the first conflict, which is underlying rule of law conflict. It's a legal jurisdictional conflict it's questions about and disputes competition over legality and legal supremacy. So which has primacy, the Constitution or European Union law? The actors which are engaging in these conflicts are courts, basically high-ranking courts, but also lower-ranking courts that are asking preliminary questions to the European Court of Justice. The questions which concern these problems is basically which law is supreme and what is illegal or unconstitutional. And there are various processes going on between these competing constitutional orders over the supremacy of law. Basically, this is expressed also in case law, in judgments by constitutional courts, or in the case law of the European Court of Justice. And the literature is basically legal literature here, and because I'm not a lawyer, I have to read this very intensively, and but I do my best. So the second conflict with constitutional, about competences. It's also about constitutional identity. What should be the European identity? What are the European values? And sometimes European constitutional identity can come in conflict with national European identity, national constitutional identity. So there can be a clash and competition over values, competences by guardians of the constitutions or guardians of the treaties. You could say also guardians of the rule of law. So the question is here, who is the guardian of the constitution? Who has the last say, the last word, the final arbiter? And who has competence? The processes underlying this conflict are dialectical processes of universalization versus de-universalization, so basically concrete constitutional order and concrete values in a nation state. Then we have also constitutionalization, deconstitutionalization dynamics. You can bring certain values into the core of the European constitutions or into the core of the national constitutions. And this is a process, a transformation which goes on, which is contesting, dominated by contestation, conflict, bringing certain values into the core and declaring them as universal values. And because the rule of law is dominated by Western traditions, although I must say that Poland has also a very long tradition and the second oldest constitution in the world after the Americans. There's, the concept of the rule of law developed mainly in Western countries, and they are dominating the core values, what the rule of law means. And countries at the periphery, they are struggling to bring in their own conceptions of the rule of law into these core principles. So this is how I see it. The form is clear, rule of law is a floating signifier, but then it has to be filled with content by nation states, by maybe even lower going to regional level. So there's also literature on this, on constitutional pluralism and basically constitutionalism, various forms of constitutionalism. Constitutionalism as a concept with an adjective. So now very famous also populist constitutionalism and political constitutionalism. And this is clashing with more legal and constitutionalism. The next conflict is political, about basically decisional, about sovereignty, it's a conflict between national and supranational institutions, between governments and, for instance, the European Commission or European Court of Justice plays a role, Parliament. So the question is here, who is sovereign and who decides, who has the ultimate decision-making power? The processes which are here shaping sovereignty, the evolution of sovereignty, is politicization, depoliticization, judicialization dynamics, and if you speak in neo-colonial terms, you could argue colonization versus decolonization. So this post-colonial framing. Literature, Bodin, Rousseau, and D.C. Schmidt, Heller, German Staatslehre, is famous in this regard. And about politicization, Zürn and Krisi here is the relevant literature. Epistemic, next the epistemic conflict, discursive conflict. This is something when I studied risk studies and the perception of risks and threats about threats to the rule of law. So you have different epistemic viewpoints and beliefs whether the rule of law is under threat or not. And this can be discursively constructed, socially constructed. Perceived risks can be amplified by discourse coalitions, by epistemic coalitions, by interpretive coalitions. And this was actually also done in the Polish case, as I will show you later. So coalitions can engage in advocacy and advocacy activism and then construct a threat to the national security, like in Romania with corruption. Corruption as a threat to national security. In Poland, in the European Union, a threat to the rule of law by populists. In Poland, maybe they speak about threat to national security by, or in Hungary, by immigrants. Yeah? So there are various threats for nations. They are diverse threats, and they, of course, they must be also considered because we have pluralism, and this is important. So there are also processes ongoing, like the epistemicization of politics, meaning that you outsource certain problems and assessment of threats to epistemic communities, to experts. This was mostly seen in the corona pandemic, where you outsourced the decision-making about measures to experts, to virologists, to epidemiologists. Now in the rule of law conflict, you outsource the decision to legal experts, to the Venice Commission, to various international bodies or courts or judges and legal experts. Basically, it's about epistemocracy and expertocracy. So the literature which deals with this epistemology and discursive deliberation, discourse analysis is below. And also Professor Bogdandi with co-author speaks about systemic deficiencies. Yeah? And the question I asked myself, whether the systemic deficiencies are constructed, hypothetical, or whether they are real. And this is also a bone of contention. Factional group, this is actually how the conflict started in Poland about the rule of law. It's a conflict about legitimacy, about authority of judges and status of judges and groups. So groups, the judiciary, even the judiciary can be divided in factions. There can be a schism between judges, and they can fight each other and delegitimize each other. This is currently happening, or happened in Poland, has happened in Poland, which undermined also constitutional order and intensified the conflict. So the question is here, who has legitimate authority and processes legitimization, counter-legitimization, and the theory is here more sociology. Weber, Elias with Norbert Elias, a German sociologist, with established and outsiders. Yeah, those groups or dominant groups which existed in the European Union. For instance, you can apply this concept of established and outsiders to the first members of the European Union, and then the outsiders, the new peripheral members. But it can be applied to the court level, where you have old judges and new judges. So this is here the theoretical framework which I propose. These questions here are quite connected and overlapping, so I have to still find out whether you can put it in under one topic, because it's very, very closely related: sovereignty, constitutional identity, and supremacy. So I have to check it out in further research. And now let me come to empirical evidence, and especially is based on the constitutional conflict between the European Union and Poland. So it started as a schism among old and new judges, whereas the old judges refused to recognize the legitimacy of the new ones. And this was basically the old judges also professors, old professors, constitutional court judges trained in Germany, predominantly as Humboldt fellows, all judges in the old judicial council, and they encountered new judges coming in who wanted to reform the system. And the Venice Commission notes this schism in the judiciary between old institutions, old judges and new judges, and recognizes that this is a battle about legitimacy and about status of judges and status also of courts, entire court chambers. So it looks actually like this, in a simplified, simplistic maybe way. There are anti-reformed old judges who are opposing the good change, the good constitutional change, which is ongoing since 2015-16. And the pre-reform judges, they are actually pushing for disciplinary measures, for maintaining judicial ethos, whether they are instrumentalizing these disciplinary measures and for power games, I cannot say here, but at least there is some kind of fortress of judicial independence fighting against a fortress of judicial accountability. Anyway, you have to balance independence with accountability, and this is a very contested process, which occurs in the Supreme Court, in the Polish Supreme Court, and in particular as a fight among chambers, yeah? Because you see the old judges and the new judges in black, and some chambers were dominated by old judges, and the newly created chambers were dominated by new judges. And both factions fought each other with law, and with other means. I will come to these means, because they include also naming and shaming and ostracism and so on, stigmatization. But after the decisions of the European Court of Justice, one of this chamber, the disciplinary chamber, was replaced by a professional responsibility chamber, where judges are now differently nominated by ballot, basically, and this conflict appears to calm down. So it's a professional responsibility chamber. And it is, you can see, there are old and new judges in this chamber, so it's almost equal. Not all judges are, that still need to be nominated to be full capacity. This factional conflict, this internal factional conflict from Poland, translated towards the European Union level. And here's an example, because these are all dynamics of inclusion and exclusion of judges. And it's translated to the European level, to the European network of judicial councils. And finally, in 2021, this network has found that the Polish Judicial Council, the KRS, does not comply with statutory rule anymore, and that it does not safeguard the independence of the judiciary. So it does not defend the judiciary, the interests of individual judges. And it voted to expel... voted to expel the KRS. So it was some kind of exclusion. Then other forms of delegitimization by old judges of new judges, asking preliminary questions about status of new judges, stigmatization, questioning status of them, considering them or naming them even non-judges, neo-judges, quasi-judges, Dubler in Poland. But the other judges reciprocate. They call them corporatist cases or rebel judges, yeah, because they are boycotting reforms and so on, procedures, voting. So this is really intense conflict going on, and unfortunately, or maybe not unfortunately, but this is the fact that the European Court of Human Rights and ECJ less, but the European Court of Human Rights is basically questioning the independence, legality, and legitimacy of these new judges, and especially the disciplinary chamber and the constitutional court. So the disciplinary chamber is not a court of law, in this case of Rečković. Then the status of the constitutional court is also questioned, although it involves a problem of overlapping mandates, and it's quite complicated. It's not so clear-cut, but the European Court of Human Rights sided with one faction of this dispute. So you see how a conflict goes to spills over to the European level. Now, the epistemic nature of this conflict is about threats, constructing threats. This was basically done through politicization in the European Parliament, in the media, and by discourse. So rule of law under threat. This happened also to Romania and Hungary, by the way. Especially the European parliamentary the parties were here in front. And leaders of these parties or members of these parties like Timmermans, rule of law under threat in Poland, maps underlined imminent, also threats, and here it's actually about beliefs of systemic threats. Don't forget this. It's not always a factual real risk. It's always sometimes related to hypothetical threats, beliefs, and beliefs about systemic threats, which is very difficult to establish empirically and by facts. Then, of course, the European Union could say that the rule of law is no more a national threat or national issue, but a threat to the European order with this rhetoric and with these justifications of threats. And you know, I live in Trier, and I go often to Luxembourg, to the European Court of Justice. During these hearings, I can observe more anthropological research, observation of judges, and then I see Polish judges appearing there, making statements in front of cameras, mediatizing this threat. Yeah, they are socially constructing and discursively constructing threats to the rule of law. Although there are disciplinary cases for sure, but this is only a fraction of the 10,000 judges in Poland. And if you dismiss some judges because they behaved or violated the judicial ethos, of course there's a controversial issues, but it's about proportionality. So I don't think it's a systemic threat to the rule of law, and it concerns only few judges, and most of them actually, they won the cases before the disciplinary courts. So it's about a couple of judges. But you see here in the pictures how the media is amplifying these threats and risks about the rule of law. And indeed, Tanchev, based on Tanchev's opinion and then the decision by the European Court of Justice, identified even a hypothetical danger, hypothetical threats, hypothetical fears. These are, I'm coming to the end, legal conflict of supremacy and competence. Here you have basically listed the Polish case law about supremacy of the Constitution, which is written in the Constitution. Then you can see the conflict on constitutional identity between liberal values and Republican values. Both are European. The president is the guardian of the constitution, according to the constitution. And a salami tactic, this is even based on a citation by the president of the Judicial Council, Leszek Mazur, sovereignty can be lost gradually according to a salami approach. And this was the threat of the Polish judges and Polish politicians, that you lose sovereignty by the decision making of European Court of Justice. Then can the counter reaction to defend sovereignty. Also, Constitutional Court judges engaged in this counter reaction, and politicians, of course. And these are the two last slides. The degree of polyconflicts varies in the rule of law according to countries. I think in Poland it's most extreme. Then comes Hungary. Romania, it was diffused, postponed, or avoided. Avoided in some countries, in Bulgaria, for instance, especially at the legal, constitutional, political level. And not always these threats and polyconflicts in the European Union are related to real or evaluations of the rule of law. Because you see, below Poland, there are a couple of countries that are similarly, Slovakia, Malta is also similar as Poland, and they don't have conflicts. So, conclusion, rule of law conflicts are overlapping conflicts, and I think they will persist. I'm quite pessimistic. They will persist for a longer period of time. It's just, I think this is the beginning. It will continue. And we need a strategy of disentanglement of these various conflicts, which is very difficult. And the extent of conflict may not coincide with the extent of deficiencies of the judicial system. Okay. Thank you very much.
And let me first of all thank the organizers for inviting me. I'm really honored to be here. And it was very interesting to listen to my predecessors. Of course, the temptation is huge to try to explain to which extent and where I agree with some of the things that were said, or I disagree with others. But I will try to stay with the idea that I had in mind while preparing for this conference, namely, what are the lessons of the pandemic? A pandemic which is still going on or is over. And anyway, my idea is that there is no rule of law in the absence of respect for human rights and freedoms. I could not agree more with you that there is a European society. I have been working for this for many, many years. Nevertheless, I guess that the truth is that you cannot impose an identity, which means belonging to your European society, by law. You may write how many laws you want, but the identity, it's something that it is a work in progress, and you are totally right when you say it is based on trust, on confidence to the others. And with this, I totally agree. It was very interesting to listen to you when you mentioned the cleavage, which is not between countries, but rather within this European society. Here I'm definitely more reluctant, because I don't want in this way to absolve governments of the kind of decisions they are responsible to take in each and every country. I have witnessed moments of wonderful solidarity in the European Union, but I also see now a level of skepticism that is more and more present almost everywhere. And to be very honest, it does relate to the subject that I chose for today, which is the lessons of the pandemic. Because I think we all can agree that between 2020 and 2022, the entire world has lived an experience which was unknown before in what we call the human rights era that reigned after World War II. We witnessed restrictions of free movement, of freedom of expression, freedom of assembly, barriers to the right to work, to proper schooling, proper education, to the right to get appropriate medical services, including for very serious diseases. And by no means, I don't want to say that the pandemic was not something very worrisome. Yes, confronted with a new virus, the World Health Organizations declared a pandemic, and each and every country accepted this. But now, 2 years later, I think we have to question how the management of fighting this virus was undertaken by the states, by the governments. They remain the ultimate responsible beyond the expert opinion, because they are the one chosen by the society to rule on us. And yes, we have to question how was the test of the proportionality imposed or implemented during these 2 years. No doubt, absolutely no doubt, this virus, at least at the beginning, in the first couple of months, created panics. People lost their lives. So let me put it this way. Some of the initial mistakes were excusable, understandable. But after a few months, not so many months, it became clear that although the virus was spreading very rapidly, it was not that lethal that people feared at the beginning. So why did we continue with the same restrictions for years and years? And please keep in mind that these were restrictions not based on law, but they were based on administrative decisions taken by governments. Just a few examples, if I may. In France, for more than 1 year and a half, it was no movement after 6 o'clock. Jesus. In Belgium, there were so many restrictions, many, really many, and then they came with this absurd rule of no visitor, 1 visitor, 2 visitors. It was, you were not allowed to drink a drop of water in the street, because that was to take off your mask. And although the street was empty, you were not allowed. Okay? Show me the law that may say something like this. Remember that in New Zealand, they closed again the borders and forbade entry in the country after 1 case. And that was months after it was known that the virus was not a lethal virus. I mean, it was, of course, unfortunately, many lives were lost, but not to that extent as to close a country. And then please remember the policy on the vaccine afterwards in France, which actually prevented medical staff, physicians, and nurses to provide medical assistance to people if they didn't accept to take the vaccine. I'm happy to say that In Romania, when it was a similar attempt, we wrote directly to the government. The government asked our opinion, and we explained why these would be unconstitutional, and they gave up. They did not anymore come with a similar legislation. To mention US, which even today has the vaccine policy, you cannot enter without the vaccine, knowing very well that it cannot prevent the infections nor the spreading of the virus. So this is why I'm saying that these were unprecedented restrictions. We never saw such a thing before. But in my view, nevertheless, the most affected right was freedom of expression. Freedom of expression was to such an extent banned that definitely those of us who were born under the communist regime, we made all the time comparisons with the censorship at that time. Who is the biggest censor, the universal censors in this new era of digitalization, social media? A sort of God replacement on earth. Zuckerberg, Facebook, and all its other companies. You couldn't question whether the virus was created in a laboratory or how. Nothing that you wanted normally to challenge with arguments, more or less solid arguments in a civilized language, nothing was allowed. They suspended posts, Facebook accounts, whatever. My problem was not that much, and is not that much with Facebook. Why I'm saying this? My problem is with the governments, where such consequences of Facebook policy in countries where the governments allowed such consequences. Why? Because Facebook is registered in a few countries in the world. You cannot go to court and challenge their decisions. But how come that the same company and the others, they are allowed to make huge amount of money of local publicity, but you as a government do not intervene when they censor freedom of expression? We do have a problem here. And it's not only a problem in my country, it's a problem everywhere in the world. There were attempts at the level of the European Union, but they failed beautifully to make some rules in this respect. As I said, of course we understand that to protect some rights, sometime it is important, and that's the rule of law, to restrict other rights. That is without question. But there is always the test of proportionality, to which extent we do this. And I have to say that every time when this test of proportionality fails, it's clear that we are in front of human rights violations. And let me give you a few more examples of what happened in Romania, although I think that people living here, they are familiar with them. In this country, for almost 1.5 years, mandatory hospitalization of healthy people, but infected with COVID, was in place until 2 negative tests were presented in 1 week, because it was 3-4 days delays between the tests. Now, so many years after, or so many months after, we know that the virus still is there, so the test will be affected. But when I say mandatory hospitalization, I want to make very clear, I'm not talking about 2-3 days, 1 week in a hospital. I'm talking about people who spend 1 month, 40 days, 50 days, 67 was the biggest number. People spend in closed rooms in hospitals without the possibility to go to the corridor. This is definitely inhuman, degrading treatment. Meanwhile, because there were no miracle medicines, they were subjected to all sorts of experimental protocols that were enforced during this period of time. We received at the Ombudsman office tens of petitions from people, and at a certain moment we received a petition signed by 720 physicians who desperately asked us to do something and to stop this situation. Unfortunately, in spite of all our efforts, we did not change it until I think it was in spring to summer 2001. Then, another example of the proportionality which was not in favor of protecting the rights of everybody. We had in this country the policy of making many hospitals COVID only. That meant that many more other people did not have access for almost 2 years to basic medical assistance or to more complicated, more sophisticated, no treatment, no early diagnosis and then treatment for cancer or whatever, no other type of medical services from magnetic resonance, tomography, whatever. We even had a ridiculous situation where we had tens of physicians and medical staff with only 1 or 2 persons in the hospitals, while others with heart attack or AVCs were obliged to go kilometers, tens of kilometers, to reach another hospital if possible. Again, we failed in our attempt to change this policy, although we did whatever we could, and it is only now, that's a little bit sad, it is only now that medical associations admit how wrong this approach was. Why now? Because now they are counting the collateral deaths. It is sad, as I said, because we are talking about human lives. Doesn't matter if they were affected by COVID or from other diseases. Freedom of movement, oh my God. In this country, at least, we had a policy punishing people who left their houses to fines up to 3,000, 4,000, 5,000 euros in a time when the minimum wage was like 250 euros. So that, I guess it was, if not the highest in Europe, among the highest, but I guess it was the highest. And only after the institution that I represent challenged the so-called law, because it was not really a law, to the Constitutional Court, and the Constitutional Court with unanimity agreed that we were right. Only at that time this policy of giving people such huge fines stopped. Yeah, but meanwhile, of course, it affected the lives of many people. Again, in this country, we had, and I think that was unique in Europe, because we had 2 years of only online classes for all category of students, from primary school to secondary to high school to university. In all the other countries, they had also online, but sometimes they had also physical. Now, in this country, it was only online, and to understand the tragic situation, I mean, this is a country with many poor people living in very remote areas where there is not even internet connection. What online classes? Let alone the fact that they didn't have, I don't know, the tablets that needed. What smartphones? Just, oh. So basically for 2 years, many children in this country did not have access to school, to proper schooling, to proper education. Moreover, they were kept prisoners in families where often, unfortunately, they were abused. And now we see the consequences, and they are tragic consequences. We are talking about children, not only children that are illiterate, but children who are suffering from depression, anxiety. The number of suicidal among children has risen to an absolutely dramatic number. Now, in all these situations, there were rules imposed by either by the parliament or by the government. Was this rule of law? I'm afraid not, in my opinion, because these types of rules that one can impose to people are also very common in dictatorships. So what? They do not care about the rights and freedoms of the others. And this is the responsibility of each and every government. Why am I so, let's say, I don't know, pessimistic or skeptical? Because I see that immediately after the pandemic, or I don't know, this overlapping or replacing it, a war started at our borders. And I insist on the fact that it's our borders, and when I say this, it's not only Romanian border, it's the EU border, because I am a European citizen, and what affects my country affects definitely the EU and vice versa. And this war, in my view, will have long-term consequences on including the rule of law, but everything that relates to rights and freedoms. Not only on the economic development, if we think of the shortage in gas supply, but more important in the, I would say, social texture of the European Union. And here is the relation with that European society, I would say. Why do I say this? Because in 2008, we went through another crisis, 2008, 2009. And it showed us very clearly that in such times, egoism replaces solidarity, as fear go hand in hand with hate, and then racism and xenophobia find their ways. Of course, scapegoating the migrants, be them from outside the EU or within the EU. But in 2008, 2009, the European Union and its citizens, I don't go that far to say European society, but the European citizens, we were strong enough at that time to reject such behaviors by means provided for by functional democracies. And my question is, will this be the case next year and the next year and the years to follow? I have to say that I am a little bit pessimistic, I am skeptical. I see that people accepted way too easy to give in their rights and freedom in the last 2 years. They did not keep their governments accountable for how they managed the fight against the pandemic. And this is why, as I said, I am skeptical. And if someone considers that I'm too skeptical, I would say this. I worked 18 years in human rights NGOs in Romania and internationally. And then I worked 12 years as a member, as a liberal member of the European Parliament. And for the last 3 years, I have been working as the Romanian ombudsman. And all these experiences taught me that human rights should never be taken for granted. Quite the opposite, we should be alert and react immediately to each and every violation. And I am indeed so alert that, for example, the European Political Community Conference, the conference that took place last week in Prague, yeah, and that was the name, European Political Community. Even this conference gave me some shivers. Why? Not because a head of state met there, but because exactly at the same time there were politicians and analysts and journalists who started to question, why do we pay so much to the Council of Europe? The Council of Europe, which is the one which gave birth to the European Convention of Human Rights and the European Court of Human Rights. So yes, allow me to be alert and to do whatever I can to fight any incipient idea of human rights violations, including using my freedom of expression. Thank you very much.
Now, we have about 5 minutes. We can probably cut a little bit into the coffee break, even though I think everybody wants to get a coffee. And we do have time for 2 quick questions, quick answers from Professor Kumbundandi, from Ombudsman Weber.
Thank you. I was about to close. So I think that if you don't have access to justice, then all these violations that you have mentioned are possible, and this is the biggest infringement of the rule of law. In the time of crisis, when everybody said that we need justice and we need judges, exactly to have someone to make this test of proportionality, we do not have it in Romania, and it was a failure of justice and was a failure of judges themselves, I'm afraid. And it was a test of democracy that we did not pass. And I just hope, but I'm also skeptical, that it will be a lesson for the future. Thank you.
In all these crazy times of pandemic, crazy for a variety of reasons, it was something that honestly made me very proud. It was how the judiciary in Romania reacted, at least in some places. Because unlike other countries, which are considered to be well-developed and functional democracy, where it was a silence, a complete silence, in this country, people started to challenge those administrative decisions that they consider not to be in order, and we had a number of courts in this country, really from all the regions, which considered as well that these were not considered legislation that were in line with the Constitution and with what the primary legislation in Romania said. It was a sort of a cat and mouse game that went that far that at a certain moment, a state secretary who was in charge with this said, unfortunately, that it's okay if people challenge and the court decisions ruled against us, we anyway can make it again and again every single month, and the court decision will take more. This is undermining the rule of law, and this is why I say governments should be held accountable for what they do. Thank you.
Yeah, I have a question to Ombudsman Weber. That was a very touching and impressive presentation. My question to you is, how do you explain that? Why did that happen? Was it for politicians who tried to gain power? Was it for some other advantage? Was it that the politicians who imposed those measures were hooked by wrong advice? Did they give in too much to international institutions? So how do you explain that happened?
Well, I guess that the answer is in the question, actually. At the beginning, as I said, I think it was a panic. and this is why I said, okay, it was understandable. It was something we were not confronted with before. So the first few months, there were mistakes, no doubt. But then, I'm sad to say, I saw that governments discovered how easy it is to rule over citizens when you deprive them of their right to express freely, to protest, to have assembly, to go to the streets. Yeah, unfortunately, this is the situation. Of course, there were also expert opinions. Experts may be also wrong. I mean, they are not gods. But from what I saw, and believe me, I definitely watched what happened everywhere. It was also this kind of, I'm in power, I have the power to tell you what to do, to give you. I was shocked by one speech, for example, the speech that President Macron delivered before Easter in 2021, yeah. When he appeared on TV and he said, this year, now for this Easter, we allow you to go 10 kilometers to visit and I was like, is this 2021 or it's Rasolei? What is this? And people from a country where they had the first declaration of human rights, okay, the droit de l'homme. People didn't say anything, they just obeyed. So the governments discovered that it's easy to frighten people and to keep them silent, and people got very easily frightened. Why? I don't know. Maybe because we are so used to live in a world of peace, in a world of prosperity for so many years that our senses were not anymore awoke. I don't know. But I see something similar now with the war. Again, freedom of expression, it's very much censored. To such an extent that I saw a couple of days ago, an analysis of the EU Observer criticizing the decision of the Council of Ministers regarding the ban on some Russia media. And other countries, Nordic countries, say, no, this is unconstitutional, we cannot do this. But again, months after. So this is where my skepticism is so strong. The fact that we need so much time until we put some of the things at least in order. I do hope that this European society you talk about is much more aware of the rights and what we are about to lose. And to give you an example, not of the cleavage, because here it's not of cleavage. I think it's more like personal experience. As I said, 12 years I was in the European Parliament. And I know the debates. And I know that countries, former communist countries, were much tougher when it was about to preserve their rights and freedoms. Why? Because our experience was very recent, while the Western colleagues and societies were more, okay, if this is the case, then we accept. No, we should not accept. And we should fight all the time. In the academic world, in the civil society, in whatever institution, you name it.
That's a wonderful note to close our panel on. So thank you all for beautiful discussion. Also, Martin, absence. All right, let's go to have a well-deserved coffee.
Well-deserved.